Okay, so let us begin with the remaining portion of the polity section. Executive ની વાત કરીએ આપણે, ચાલો એક્ઝિક્યુટિવને ચાલુ કરીએ. તો ભાઈ ફર્સ્ટ ઇઝ ધી doctrine of neutrality. Why there is a need for a doctrine of neutrality? The first is that to uphold the constitutional trust, such as in the case of Speaker, political fairness, CBI, CBC, and CBS, upholding federalism, continuity, checks on executive, and a fair system of election. अगर इलेक्शन कमीशन biased હોય તો fair system ના રહે ને. હેલ્થ ઓફ ઇકોનોમી કેગ વેગ માટે જરૂરી છે. ઓકે, હવે આપણે એક એક વખડી પ્રાઇમ મિનિસ્ટર. ડૉક્ટર બી આર આંબેડકર said that if any function is to be compared under the constitution with that of president of USA, then it is prime minister. Okay, Lord Morley has said that a primus inter pares functions in relation to council of minister. He appoints minister, he reshuffles various portfolio ministers to resign, preside council of minister, guide them, direct control coordinate activities of minister, can bring collapse of council of minister by resigning. Okay, yes. In relation to president, he is the principal channel of communication of council of minister to furnish information, submit for the consideration of council of minister when the decision is taken by a minister, advise appointment of important officials like AG, CAG, among others. Okay. In relation to parliament, it advises summoning and proroguing the session of the parliament, dissolution of Lok Sabha, government policies on the floor of the house. Okay, three things. What are the other powers? Chairman of many various institutions such as National Disaster Management Authority, and then National Wildlife Board, yes, many others. Shaping foreign policy, yes. Chief spokesperson, yes. Crisis manager in chief, leader of nation and leader of party and political head. Okay. About prime minister's office, there's so many things to talk about prime minister's office. First is the secretarial assistance and crucial advice to the prime minister. Extra constitutional body. So yes, the PMO enjoys the status of a department of the government of India under the allocation of Business Rule 1961. No attached or subordinate office under it. Okay. History, it was in 1996 to 1991 that PMO played a very crucial role in response to balance of payment crisis of 1991. Vajpayee made it a very active in triple area, especially economic, foreign policy and security framework. Okay. Functions like we mentioned above, assisting in prime minister, maintaining liaison with central ministers department and the state governments, acting as a think tank of the prime minister, deals with all such subjects which are not allotted to any other ministerial department. It is not concerned with the responsibility of prime minister as a chairman of union cabinet. Okay. Role of cabinet, role of cabinet committee. So Ramsay Muir says that cabinet is the steering wheel of the ship of the state. Lowell has said that cabinet is a keystone to political arc. Okay. Role, it is a highest decision making, chief policy formulating body, super executive authority, chief coordinator of central administration, advisory body to president, chief crisis manager, deals with all major legislative and financial matters, exercise control over higher appointments, foreign policies, among others. Okay. Governor, Article 153 to 167, Part 6 of the Constitution. Why not direct election? Why there was no direct elections? The first is incompatible with parliamentary system, creates conflict between governor and chief minister. He is a constitutional head. He has to maintain political neutrality. So if there would have been election, then there would have been party. So politics would have been involved. Create separatist tendencies. Sent to maintain control over state. A serious problem of leadership at the time of general elections. Okay, yes. Chief minister would be like a nominee to contest for the governorship. Okay. Power, executive, legislative, financial, and judicial. We mentioned about the president, so same things happen with the governor. Okay. What are the discretionary power under Article 163? He has many discretionary power. First is 163 article itself has given that he has to aid He has to work based on the aid and advice of the Council of Ministers unless that decision is exercised as a power of a discretion. And who decides whether it was a part of it, whether it was a discretion or not? Then it is Governor himself. Reservation of the bill for the assent of President is 201. Recommending President rule under Article 356. Function as an administrator of adjoining duties, determining the amount payable by the government of Assam, Meghalaya, Tripura, Mizoram to the tribal district council as royalty accruing from the license for mineral exploration, seeking information from chief minister, determining laws not applicable to autonomous district council. There are certain situational discretions too, such as the hung assembly, dismissal of council of minister, dissolution of state legislative assembly. Okay. Ordinance making power of president is under 123, and 213 is the ordinance making power of the governor. And Cooper case, that repromulgation of ordinance merely to bypass the legislative procedure is a fraud to the constitution. Yes. Okay, so almost everything is same between the ordinance making power of president and governor. We'll look at it. Only when no or one is in session. Okay, either Lok Sabha or Rajya Sabha, only one of the houses in session, or no houses in the session. Satisfied that circumstances exist, a need for making an ordinance. Only on subjects for which Parliament can make law. Same force and effect as law. Can withdraw ordinance at any time. No discretion. It is not a discretion. Okay. Ordinance should be laid before both the House of the Parliament, expiring 6 weeks from the reassembly. No instructions for making ordinance. Okay. Required in some case. Vice President, so what are the issues? The federal question, yes, that what is the exact role of Vice President? And again, no role of state legislative assembly in appointment of Vice President, yes. Difficult to get non-political candidates elected, yes. Procedure for nomination not consensual. Barriers to electoral participations. System of parliamentary representative used mostly when more than proportional representation used when more than one of the candidate needs to be elected. Yes. Okay. So here we need only one. But yes. Okay. Limited role. Yes. President arbitrary exclusion of nominated members from the election of president. 1971 census-based calculations, which is bad. Difficult to find non-political people. Yes, okay. Financial emergency, Article 360. President can declare when satisfied that such situation has arisen due to which a financial stability or credit of India or any part of its territory is threatened. Okay. Dr. B.R. Ambedkar has said that the article follows the pattern of National Recovery Act 1823 of USA. Okay. Effect. What are the effects? Center extend directing states to observe canon of financial propriety and direction as president may deem necessary for the purpose. Reduction of salary allowances. Yes. Reservation of money bill for the president's consideration after passed by the state. Press direction reduction of salary allowances of all or any class of persons serving in union when budget judges and the salaries of judges and high courts. Okay. Judges of Supreme Court and High Court, I beg your pardon. Criticism by H.N. Kunjru is that financial emergency provision poses serious threat to the financial autonomy of the state. Federal character is destroyed. The power of state goes to the president, and the president acts as a dictator. Financial autonomy of the state is hampered, and again fundamental right is again hampered because of freedom to profess, freedom to gain services. Again, talking about president, Article 52 of the Indian Constitution. There shall be president of India. He represents the nation but does not rule the nation. He is a symbol of nation. Dr. B.R. Ambedkar says that tallest summit of the statehood, okay, president. So let us highlight this, the tallest summit of the statehood. Election Article 53, 54, 50, 66, President and Vice President Elections Act 1952, about almost 35. Okay, so this, it was during the election, so we will not read this now. Perception President, okay. Era of Nehruvian presidency, ceremonial irrelevancy, rubber stamp, yes. Assertive president, okay, I beg your pardon. Let me come again. So actually, our president has been very very different. Okay, such as in the era of Nehruvian time, it was just a ceremony. That Fakhruddin during the emergency period was just a rubber stamp. Gyal Jail Singh, he actually was an assertive president, so he used pocket veto. Okay. K.R. Narayan is known to be an outspoken president, very popular. Refusal to he denied to apply president rule in Uttar Pradesh. Okay, and People's President Abdul Kalam, yes, President of Mercy, Pranab Mukherjee, he accepted mercy plea of many prisoners. Okay, so often he is criticized as a rubber stamp. So yes, if you read Article 752 with 74 clause 1, he is to abide by the aid and advice of the Council of Ministers. Okay. Samsher Singh case versus Union of India case, he said that President is a constitutional head, and 42nd Constitutional Amendment Act, he made it compulsory to give assent. Article 123 Ordinance with Council of Ministers recommendation, 52 clemency power, 72 I beg your pardon, and X11 veto power. So yes, everything is used based on. So these things say that it is a rubber stamp. He is a rubber stamp. But he is not a mere rubber stamp, because Rashtrapati Bhavan as statutory instrument to hold national together. Okay. Kalam visited during Gujarat Road. Yes. Public Institution of India by James Mehra. Central to Republic, opposition support to Draupadi Murmu. Yes. Exercise clemency power. Pranab went against Council of Ministers again, advice. Exercised of pocket veto, Jan Jail Singh. Administrator of UT scheduled areas and appoint commissions to investigate welfare. Head of armed forces, voice to mobilize public opinion. Yes. Issue with electoral college. Yes. Interstate disparity is there. Sikkim versus UP. Value calculated as per 1971 census. Parity tilted towards bigger states, UP, MP. Yes. Difficult to fill non-political leaders. Yes. Okay. So these are the issues. Talking about executive power, all executive actions, appoint Prime Minister, appoint CAG, CEC, UPSC, Governor, Finance Commission, AG, 6. Any information relating to administration of affairs of the Union, require PM to submit consideration of Council of Ministers on any matter. Appoint a commission to investigate into the condition of SC, ST, OBC. Appoint interstate council, direct administer UT, can declare scheduled area, make rules for the convenient transactions of the business and allocation of portfolio. For legislative, summon and prorogue and dissolve Lok Sabha joint sitting, address the Parliament, send messages to the House on bill pending in the Parliament. Member to preside Lok Sabha, nominate 12 members, decide on disqualification of MPs, right? Prior recommendation and ascending power, bill reserved for the President, promulgate ordinance, lay report of CAG, UPSC, Finance Commission on the floor of the House, make regulations for peace, progress and good governance in Andaman Nicobar, Lakshadweep and Dadra Nagar Haveli and Dadra Nagar Daman and Diu. Nature of ordinance power. Madam B. Lakur has said that legislature is not in session. Circumstances that warrant it. Circumstances are urgent. Exceptional is not normal. Advice of Council of Ministers and no parallel power to legislature. Okay. How it is being misused. Repeated promulgation. DC advocacy, you can quote this. used to bypass legislative scrutiny, Land Acquisition Act, agriculture law, undermine separation of power, increasing recourse to ordinance in 1951 7.1. However, by 2020, almost 15, nearly doubled the ordinance making. Not restricted to exigencies, undermine the parliamentary scrutiny. Okay. Safeguards such as the 6 week clause, RC Cooper case, yes, it is subjected to judicial review, constitutional morality, popular pressure, public protest, among others. Okay, so there are some certain safeguards, but these safeguards are not that strong. Financial powers, let us see in the financial link, money bill, at prior recommendation based on before money bill has been laid on the floor of the house. Indian financial statement, no demand for grant can be made except on his recommendation. Advances out of contingency fund of India, Article 161, Finance Commission appointment. Judicial powers such as appoint CGI under Article 124, seek advices under Article 143, grant pardon under 72, reprieve, which is stay on the term period, respite, that is special category. For example, a woman is pregnant and he needs some respite. A remission decline, period decrease, but cruelty remains the same. Okay, suspend, remit, or commute. Okay. Maruram versus Union of India case, exercise of clemency power on advice of Council of Minister. Shatrughan Chauhan versus Union of India case, inordinate delay and unexplained would lead to commutation. Okay. Epuru Sudhakar case, judicial review applicable if without application of mind and malified order or arbitrary order. So these are the cases for pardoning. It's not a privilege based on principle, not an extension of judicial power, works on a different plane, a re-examination of facts, evidences, etc. And newly disclosed information needs to be taken into account. Appropriate remedies need to be fashioned. Sovereign opportunity to ensure punishment of death are merited, deserved, just and fair. Clemency about opening new doors of justice, not a gift but a responsibility. Okay. What are the diplomatic powers? International treaties concluded on his behalf. Okay, and there are veto powers such as the absolute veto in the case of PEPSU, appropriation bill, salary allowances and pension of MP amendment bill, pocket veto, Indian Post Office amendment bill, suspensive veto was used on state bills and ordinary bills can be sent once back. Emergency provisions, Dr. B.R. Ambedkar has said that Article 356 would remain dead letter and would be used only as a measure of last resort, which is never a true, which it did not materialize the way Dr. B.R. Ambedkar would have thought. Okay. So, national emergency is under Article 352, President is under 356. Security of India or part threatened by war, external aggression, or armed rebellion. Okay, so this was changed under 44th Constitutional Amendment Act. President Constitutional Breakdown or Center's Direction, Article 365. State functions normally, state dissolved, executive dismissed. Okay. Parliament can make law on the state list and cannot delegate. Parliament delegates power to the President to make law for the state list. Continues indefinitely without the approval, with approval every 6 months, maximum 3 years you can do it. Relationship of center with all the state undergoes a modification, only with the particular states. Special majority, simple majority. Affects fundamental rights, no effects. Lok Sabha can pass resolution of its revocation, no such provisions, President can revoke. Okay. Significance of emergency provision. At the time of war, handle internal crisis in 1972, financial emergency for dire financial crisis, allow legislative maneuvering by center, allow for executive synergy, allow for fiscal space for the prudence of financial management. Constitutional breakdown. Mahavir Tyagi called it a safety valve. Okay. What are the issues with the president rule? Of course, there are many issues that prone to political misuse. Nehru used to use president rule against communist Kerala government. Prone to overuse. It is used more than 100 times. Yes. Used by political Upmanship by central government, yes. State made to feel less than municipalities. Issues with the emergency. What are the issues with emergency? So, misuse for self aggrandizement, yes. Committing atrocities and imposing illegal cost. Political misuse, yes. H.V. Kamath says that it is this chapter lays the foundation for totalitarian state. Yes. K.T. Shah, chapter of reaction and retrogression. Okay. To arm center with special power against the units, government against people. D.T. Krishnamachari says that this chapter of emergency forms a constitutional dictatorship. So once again, misuse for self-aggrandizement, committing atrocities and imposing illegal cost, political misuse, totalitarian state, chapter of reaction and retrogression, to arm center with special power against the unit and government against the people, form of constitutional dictatorship. Okay, so for which S.R. Bommai case came in 1994. The first is that President rule proclamation is subjected to judicial review, satisfaction of President based on a relevant ground. Burden lies on the center to prove that relevant material exists. Power to restore dismissed state government and revives state legislative assembly. Okay, power to restore dismissed state government and revive state legislative assembly. State legislative assembly dissolved after parliament's approval. Secularism is a part of basic structure. Majority at the floor of the house. Okay. Party other than party in center cannot be a criteria to dismiss government. So that's it, my friends. Let us go into judiciary. Supreme Court, Article 124 of the Indian Constitution and 213 for the High Court to provide for the appointment of the judges. Appointment of the judge. First judge case 1982, 1993, 1998, and then 2015. Okay, and 1982 during the period of Indira Gandhi, 1993 Narasimha Rao, 1998 again a very fragile period in the Indian polity, and 2015. Independence of Supreme Court, mode of appointment, security of tenure, fixed service condition, expense charged on Continental Fund of India, conduct of judge cannot be discussed. Yeah. Ban on practice after retirement, power to punish for its contempt, freedom to appoint its staff, jurisdiction cannot be curtailed, separation of executive, Article 15. Okay. Jurisdiction and power of Supreme Court. It has original jurisdiction over central state, interstate, president and vice president. It does not have jurisdiction over pre-constitution, any treaty that specifically excludes the jurisdiction, interstate water dispute, matter referred to Finance Commission, disputes of commercial nature, recovery of damage by state against the center, expense and pension between center and state. Okay, so these are the issues that cannot be part. It's not a jurisdiction of Supreme Court. Writs, habeas corpus, mandamus, prohibition, certiorari, quo warranto. It also has appellate jurisdiction, advisory jurisdiction, court on record. Yes, power of judicial review, and then there are other powers. Okay. Talking about judicial review, it was for the first time came in Marbury versus Medicine case 1803. Constitutionality of legislative and executive order. Okay, it checks the constitutionality of legislative and executive order. Judicial review on constitutional amendment on legislation of Parliament, administrative action of the Union. Importance: it establishes the supremacy of the Constitution, federal equilibrium, and protects fundamental right. Okay. Yeah. What are the examples? So Shankari Prasad in 1951, Golaknath case in 1967, Keshavananda Bharati case 1973, Minerva Mills case 1980. So these are the good examples of judicial review. What are the constitutional provisions of judicial review? Is 13, 32, 131, 132, 133, 136, 142, 143. Yes, okay. Talking about judicial activism, it is a proactive role played by judiciary on protection of rights of a citizen and in promotion of justice in the society. It is a proactive role played by the judiciary in protection of the rights of the citizen and promotion of justice in the society. Doctrine of judicial activism was introduced in mid 1970s by Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, and Justice Chinnappa Reddy. Okay, leave this. PIL is an outcome of judicial activism. Okay, what are the benefits? Dr. B.L. Vadhera said that a near collapse of responsible government, erosion of confidence led to the beginning of judicial activism. Citizens of the country look up at the judiciary for the protection of their rights and freedoms. Judicial enthusiasm led to PIL. It liberalizes the principle of local standing. Okay, you can do something for social reforms. Even judiciary is taking part in the social reform. Legislative vacuum. Judiciary tried to fill in this legislative vacuum, and judiciary wanted to play an active role. Okay, what are the concerns? So here Upendra Bakshi, as a political thinker, has written that the judicial activism can suffer from ideological fears. So if your ideology is tilted towards conservatism or liberalism, you can actually dictate what you want. Epistemic fear, it lacks expertise. Yes, management fear, legitimacy, those things such as banning on the firecrackers or banning the sale of liquor in the 500 meters up of the highway. I mean, how would you manage it? Legitimacy crisis, yes, that you are trying to delegitimize legislature, parliament, yes. Democratic fear against the separation of power, yes. Biographic fear, like it would lead to an overdoing, undermine separation of power, asymmetry of power, lack of accountability, yes, threat of credibility of judiciary, yes. Since it is having already so much burden, it is almost a case pending, about 4 or 5 crore cases are pending, and still you are doing indulging into judicial activism is a matter of concern. Okay. Judicial restraint, original intent of author of the constitution and its amendment is knowable and must guide courts. Non-elective, okay, non-responsive to the popular will, yes. Separation of power, federalism, yes, dependent on executive and public acceptance. Law being process of a reason. Okay. The original intent of the author of the constitution and its amendment is knowable and must guide the court. Non-elective. They are non-elective, right? Non-responsible to popular will. It hampers separation of power. It breaks federalism. It is dependent on executive and public acceptance, and law being process of a reason. So please take a restraint. Okay. PIL, it's a strategic arm of legal aid movement and is intended to bring justice within the reach of poor masses who constitute low visibility area of humanity. So PIL, again, it's a very good definition. You can use this. Judicial overreach, certain examples. What judicial? It's a very thin line between judicial activism and judicial overreach. But if you have to define judicial overreach, then it is an infringement or the judiciary was surpassing its jurisdiction and interfering in the task of legislature and executive. Okay. Change in oxygen level during COVID-19. Yes. Examples: ban on sale of liquor in 2 districts. National anthem, you need to stand. Diwali firecracker ban, among others. Okay, so this is judicial overreach. Okay, current affairs. Indira Banerjee also recused. So no, they did not need this. Issues. What are the issues with judiciary? So here we have written so many issues. Okay, you can see that about almost 25 issues are there. You need to check and think what issues you need to take into consideration. Okay. So we can go for a stakeholder, that structural issues, inclusivity, issues with the judge, issues with superiority complex, poor technological adoption. Okay, so there are various stakeholders. So you can also go from this government, judge, judiciary, justice system, and so you can go based on the stakeholders. Okay, so let's begin. The first is that yes, pendency of cases are very high. Okay, national according to National Judicial Data Grid, almost this has reached to 4 crore, 4.5 crore. Okay, of which 2.5 crore cases are pending in the subordinate courts. Okay, almost 70,000 is pending in Supreme Court, so which is a very big trouble. Judicial overreach, yes, it disrespects the jurisdictional sanctity enshrined in the Constitution. Low public expenditure on justice delivery. The per capita expenditure on free legal aid is almost at only 75 paisa per annum. Low judge to population ratio. Okay, we have 20 per million. Law Commission reports 50 per million. Okay. Inadequate representation of women and minorities. Only about 3 women are there. Yes. Contempt proceeding issues against the principle of natural justice and conflict of interest. Okay. Contempt proceeding, it is against the principle of natural justice and conflict of interest. Delay, disposal delay, NCRBC says that as per the present statistics report, 67% under trial, 80% cases take more than 10 years to complete. Recruitment delay by collegium system. Okay, poor technological adoption, yes. Non-transparent, not under the preview of RTI Act. Collegium system, yes. Allocation of cases, which is very even that is not mentioned. Okay, issue with collegium system. What are the issues? Conflict of interest, closed door affairs, yes, uncle judge syndrome, promotion of mediocrity, low judiciary working days, only about 188 days. Well, there's a need for 220 days. Okay, government litigation in almost 46% of the cases. Vacancy is very high. Okay, in case of Patna it is almost close to 60%. Extrajudicial pronouncement by panchayat, such as in the case of UP, girls are banned from wearing shorts and using phones. Okay, miscarriage of justice. Okay, Delhi High Court recently acquitted a couple who was actually charged with some case, and that case went on for nearly 2 to 3 generations. So yes, judiciary is at the whims and fancies of an individual judge. Matter listing, important people, small matter gets urgent hearing. Okay, delay habeas corpus hearings, such as especially in the political opponent case. Okay, ask government to hand documents in seal covered. People's right to know is sacrificed. Okay, transfer of judges questionable and controversial, such as in the Madras Chief Justice of Madras was transferred to Meghalaya. Economic impact of judgment, such as liquor, coal block, 2G scam, and as per Niti Aayog, almost 9,000 crore revenue loss from 5 verdicts by NGT and Supreme Court. Okay, overlapping jurisdiction at subordinate courts, language issue, major issue, lack of judicial impact assessment. Okay, judges in the Rajya Sabha, it was an old issue. Now it is all gone, so you not study about them. Okay. High Court, let us first look at the static portion, and then we'll go into the current affairs. Okay, matters. Original jurisdiction, matter admiralty, like will, divorce, company laws, contempt, election of MPs and MLAs. Okay, revenue matter, matters about fundamental rights, transferred case from subordinate courts are all part of the jurisdiction of High Court. Control over subordinate courts, consulted by governor in matter of appointment, posting and promotions of the district judge. Deal with the matter of posting, promotion and grant of leave, transfer and discipline of member of judicial service. Withdraw cases pending with subordinate courts. Law is binding to all subordinate courts. Okay. Subordinate court article 233 to 237 of part 6. Yes. Article 39A Legal Service Authority Act 1987, which gave Nalsa and Dalsa district free and competent legal service, conduct court adalats, yes, organize legal awareness campaign in rural areas. Okay, talking about Lok Adalat, forum where cases of dispute which are pending in the court or which are in the pre-litigation state are compromised or settled in amicable manner. From 2006 to 16 to 20, National Lok Adalat has disposed total over 3 crore cases, which is very big. What are the concerns? It undermines the idea of justice, such as in the case of Bhopal Gas tragedy. So, in this Bhopal Gas tragedy, Lok Adalat were established, and in this Lok Adalat, those rich people, those who were responsible to give compensation, they tried to persuade, not just persuade, but pressurize them to take compensation, which is a very low amount. Okay, so compromises are often imposed on poor, accepting discounted value to bring legal process to an end. Poor women have no other option besides compromising. Yes, it is a permanent case up to 10 lakh rupees, decide on merit to award final and binding. It is based on the Gandhian principle of alternate dispute redressal, no court fee, procedural flexibility, and speedy trial. Parties interact friendly, binding to the parties, justice in the manner of common man can understand, based on the compromise and settlement. Okay, so these are the benefits actually, and these are the concerns. Okay, family court enacted in 1984, and disputes relating to marriage and family affairs. Okay, Gram Nyayal Act 2008, both civil and criminal jurisdiction appeal to the district court. Almost 5,000, there are about 5,000 Gram Nyayalaya. Okay, issues. What are the issues? Reluctant of police official to invoke Gram Nyayalaya jurisdiction. Lukewarm response from bar, non-availability of notary and stamp vendors. Problem of concurrent jurisdiction. Almost in about, it is set up only in 11 states. Only 208 are functioning. The task was to functioning of 5,000. Okay. What are the reforms that can be suggested? ADR Article 39A, 3A is afford access and availability. Okay, we need to fast track our courts. Okay, so fast track courts are already established. What are the issues? There are systematic issues, inadequate judges, no legislative clarity, lack of feedback and updation. Okay, CJI under RTI, yes. Supreme Court versus Subhash Chandra Agarwal case 2019, wherein CJI is brought under right of information. Online justice delivery system. Okay, what are the pros? Parliamentary Committee on Law. Parliamentary Committee on Law have stated that addressing the locational and economic handicaps, okay, ensure safety of vulnerable witnesses providing testimony. Cheaper, faster, addressing the locational issues, okay, ensuring safety of vulnerable witness providing testimony. So again, this is for the second time. Expedite the process and procedure and citizen friendly. Cons: infra, unique process of law, facial expression, nuanced argument, appealing for compassion. Okay. Niti Aayog has said that online dispute resolution handbook, it has published online dispute handbook. We have e-court mission mode project, national judicial data grid, judicial service center, interoperable criminal justice system among others. Okay, we have Samadhan for MSME, we have Vivad se Vishwas, we have e-court. Okay, and Chhattisgarh. What are the other way forwards? We can have all India judicial services. So all India judicial service, let us think of that. All India judicial service, what are the benefits? That first of all, it can reduce vacancy, enrich the quality of justice, address the lacuna of state mechanism to attract best talent, cooperative federalism, yes, better bar bench relation. Okay, what are the challenges? Fear of centralization, problem with language, independence of judiciary, against the SOP, separation of power, fear over reservation and examination, local laws. Okay, what is the way forward? 116th Law Commission, said that National Judicial Service Commission. There could be this in National Judicial Service Commission, and this commission should be entrusted with task of conducting an examination. Okay. Judicial impact assessment. Yes, strengthening Gram Nyayalaya. Yes, ADR. We can focus on ADR. Model code of conduct for lawyers. Adversarial legal system to inquisitorial legal system. Economic Survey 2019 for 100% case clearance issue. Additional 2,500 judges in subordinate court. Increase the number of judges to 34. Okay. CGI. For CGI, judiciary is the guardian of the constitution. It is implied that legislature and executive are equally guardian. However, it is important that all three wings of the government work in complete harmony. Okay, so you can quote this Dr. A.S. Anand. For conclusion, you can use SDG number 16 that provide justice to all and build effective, accountable, and inclusive institutions. Okay, contempt of court. Again, it's not a big issue now, but it was once. So I think we can skip it. Okay. Let us study about constitutional bodies, and then we'll study electoral system. Okay, maybe I think we should take it in the next lecture. Constitutional bodies, and the second would be the last would be electoral system in the next lecture. Okay, so yes, thank you very much.